Welcome to this seminar on preparing for Brexit. My name is Luke Donockley. I'm a solicitor at Newcastle law firm Muckle LLP, and we want to talk to you today about some of the steps that you can take to get your businesses ready for primarily a no-deal Brexit, but into the future a free trade agreement if that's where we end up. So what we're going to look at today are three main areas. We're going to look at the EU and some basic concepts, because if you understand the basic concepts about the EU, they're really the foundation for your understanding. Once we've got that, we're going to have a look at 7 steps that you and your businesses can take to prepare for Brexit. And then we're going to have a look at your contracts, which is one of the 7 steps. It's doing a legal risk analysis. We're going to concentrate on that and have a look at how those contracts might help you mitigate some of the risk of a no-deal Brexit. So, the EU, some basic concepts. What we're going to think about today are what we call the 2 pillars of Brexit. We're going to have a think about trade deals and rules of origin, because that's ultimately where the current government wants the UK to end up. And we're going to have a think about why you should be planning for no deal and why that makes sense for your organisation. So the 2 pillars of Brexit. The 2 pillars of Brexit are leaving the single market and leaving the customs union. So let's have a think about those 2 things. First of all, what is the single market? The single market is a group of countries, essentially, we call them EEA countries, that have got together and decided to have the same rules for the same products. We call it regulatory alignment. And this is all about removing what we call non-tariff barriers to trade. So it's about the free movement of goods. So to take an example, if you manufacture a product in the UK, it will comply with EU rules for that particular product. Because it complies with rules in the UK, you can export it to, say, Germany or France or Spain or wherever else in the EU, and and the consumers in that country will know that it meets the rules of the single market. So what that means is that there doesn't need to be checks at the border, checks on paperwork and further regulatory tests. And that helps with the free movement of goods. Now, the UK is leaving the single market. So one of the 2 pillars of Brexit, one of the things you need to understand to really understand how Brexit's going to be affecting your business is what will the effect of being out of that regulatory regime be? And one of the effects is that you might encounter delays at ports or have to comply with a different regulatory regime when you're exporting products into the single market. We'll have a little bit of a think about that later on. The consumer in the country you're exporting to can rely on something called a presumption of compliance, which is just an assumption that essentially your product meets the standards of the single market. And if it doesn't, then they can go to the European Court of Justice, and the European Court of Justice will enforce the rules. So, leaving the single market, one of the 2 pillars of Brexit, something that is going to cause your companies some issues, as we'll look at during this webinar. The other of the 2 pillars of Brexit is leaving the customs union. Most people have a good idea of what the customs union is, but there's some interesting points to make about it. So essentially, the customs union is also another group of countries that have got together and decided, actually, we don't want quotas and we don't want tariffs between our countries. We want to be able to move goods around freely. And again, this is all about the free movement of goods. And that's great for your business, because it means you can export to anywhere in Europe and not have to pay a tariff at the border. This only works because of something called a common external tariff. So the common external tariff is a tariff that every importer in the EU has to pay on goods that come in from outside the EU, what we call a third country. So to give you an example, it may well be that you are a British manufacturer of cars or an Italian manufacturer of cars, and you want to import some steel, say, from outside the European Union to incorporate in your cars. Both the UK manufacturer and the Italian manufacturer have to pay the common external tariff, so they both have to pay the same tariff. That means there's a level playing field between companies and between countries, and no one gets a competitive advantage. Once that steel has got into, say, the UK, it can be incorporated into the manufacturer's product and shipped around the EU without any further tariffs when it reaches the border. So it means the car can be exported to franchises in Germany and France and Spain and wherever else, and every time it crosses the border, it won't incur a tariff. So that's how the customs union is intended to work. A lot of Brexiteers dislike the European Union because of the customs union, and in particular because of the common external tariff. Because what they say is, look, we want to sign a trade deal with, say, the United States of America. If that were to happen, the UK would essentially say to the US, look, we want to get your equipment into our country at zero tariff, and we want our equipment to be exported to your country at zero tariff. So let's get rid of that tariff barrier. Well, if the UK were to do that and remain inside the EU, that would put the UK at a big advantage over, say, a manufacturer in France, because the manufacturer in France would be paying the common external tariff. So it just wouldn't work. The whole system works together because everyone pays the common external tariff. So that's why we can't sign bilateral free trade agreements, and that's why a lot of people think we'd be better off outside the customs union because we can sign our own free trade deals with other countries on our own terms. It doesn't mean we don't have any free trade deals. The important thing to remember is we have them, it's just that the EU negotiates them. And the EU negotiates them because they've got to apply equally to all countries in the bloc because of the common external tariff. Remember, we'll be leaving the customs union as well as the single market. So what that will mean is that when you get to a border, there will be a tariff applied to goods leaving the UK, and eventually, and we'll discuss this a little bit later on, possibly a tariff on goods coming into the UK. So that increases costs, it puts up friction, and that's what people talk about when they talk about frictionless trade. The single market and the customs union allow frictionless trade within the EU because they allow products to move over borders without tariffs and without non-tariff barriers. Outside of that system, these tariffs will suddenly be erected, and that's something that your businesses may have to deal with. So where does that leave us? Well, in the event of a no deal, that leaves us on WTO rules. So WTO is World Trade Organization. The UK is a member of the World Trade Organization, and separately, the EU as a bloc of 27 is also a member of the WTO. We won't have a free trade deal if there's a no deal Brexit. The withdrawal agreement that we are trying to agree isn't a free trade deal. It just says how we're going to leave, but obviously a no deal is leaving without even the withdrawal agreement signed. So there'll be no agreements whatsoever in place between the UK and the EU. So we trade with each other on WTO rules, and they really are the lowest common denominator. People don't want to trade on WTO rules, and that's self-evident. It's not political. No one would ever bother signing a free trade agreement if WTO rules were somewhere you wanted to be. So the UK would look to sign a free trade agreement with the EU and move off WTO rules, but that's where we'd be in the interim. One of the interesting things about the WTO rules is something called the most favoured nation principle. So what that says is that if you extend an advantage to a WTO member, you have to extend the same advantage to all WTO members equally. And that's really important for your business in the event of a no deal. Because what may happen is the UK may decide, actually, we will set our tariffs to pretty much zero. Now, the EU won't do that. The EU will apply the common external tariff. So on WTO rules, no free trade agreement between the UK and the EU, they will apply the common external tariff on goods going into the EU. The UK government say, well, okay, to keep trade going, we probably want zero tariff, so we won't apply a tariff. But if the UK doesn't apply a tariff to goods coming in from the EU, it can't apply a tariff to goods coming in from any WTO member, because under that most favoured nation principle, you have to treat all of the members of the WTO in the same way unless you have a trade deal. So what that means is that not only will there be no tariffs for goods coming in from Europe, there'll be no tariffs for goods coming in from anywhere in the world. And that means that you might find that Britain is flooded with goods from places like Brazil and India, China, places that can undercut us in terms of labour costs and so on, as well as having the problem of paying a tariff to get goods into the EU. So let's have a think about free trade agreements. We can get around this by signing free trade agreements, essentially. So if you have a free trade agreement with another country, then you don't have to apply the most favoured nation principle to that country. So you want to be in a position where you sign as many free trade agreements as possible. The UK is having to start from scratch at this, and on screen there are a list of all the places that the UK has to date signed a free trade agreement with. Places like Tunisia, Lebanon, Pacific Islands, the Palestinian Authority, some quite big areas like Eastern and Southern Africa that has something like 570 million people living in it, but the 530 million consumers that live in the EU are probably more likely destinations for your products. So a long way off the UK, I think, from being in a position it wants to be, and a lot of free trade agreements will take quite a while to negotiate, and so that list will be built slowly, and the advantages, as many see it, of leaving the EU will be built up slowly over the years as those free trade agreements are put in place. Some people say, well, can't we just agree a free trade agreement with the EU? Well, first, what is a free trade agreement? Well, it's just an agreement between two countries, essentially, that they will reduce tariffs and quotas, generally to zero. And some people might say, well, okay, if that's the case, if it's all about having zero tariffs, zero quotas, what's the point of being in the custom union? Why tie our hands? We can have a free trade agreement with the EU, and we can have free trade agreements with other people. And really, the problems lie with something called rules of origin. So, transshipment and rules of origin are a problem that the EU has sought to combat, and the rules of origin is the solution to that problem, really. And it's best illustrated with an example. Imagine you are an American producer of machinery and you want to get your goods into Europe. You have to pay the common external tariff. And you think, well, actually, my competitors in Canada, they've got a free trade agreement with the EU, so they can export their goods and they don't have to pay the common external tariff. So they're at an immediate advantage to us. Their products are cheaper. So the American producer of goods might think, well, actually, rather than build my product in America, why don't I build it in Canada? Manufacture all the products in the US, all the component parts, but ship them over the border, assemble them in Canada, stick a made in Canada sticker on the excavator or the bulldozer or whatever it might be, and then export it to the UK and say, hey, this was made under a Canadian EU free trade agreement. What the American producer has done is something called transshipment, and they've essentially given themselves a massive commercial advantage because they are protected by tariffs that are levied by the US government, but they've got around the common external tariff. So what the EU do is they talk about rules of origin, and they say, look, that's all very well, but a certain percentage of the value of the goods has to come from the country with the free trade agreement. So in this example, say 50% of the value of the machinery would have to be added in Canada, and that's obviously not something that the Americans can show, and that stops transshipment. So what does that mean for UK businesses in the event of no deal and potentially going on to sign a free trade agreement? Well, what it means is that your business will have to prove where its products come from, and that isn't as simple as it sounds. You might think, well, okay, my product is some agricultural good, and I can prove that it was made in a field in Cumbria, and if that's the case, that's great. But if you're in a supply chain, you're going to have to speak to your suppliers and say, well, where did you get your products from? And they might say, well, we got them from Scotland and Wales and the southeast of England, but then you'd have to say, well, where did they get their products from? Because remember, the value of your product has to be added in the UK. And this is a problem when you think about rolling over free trade agreements. A lot of people in the press have been saying, well, can't we just roll over our free trade agreement? So we've got a free trade agreement with Japan, can't we just roll it over? And the problem with that is that it's very easy at the minute to show that 50% of the value of your product was added in the EU, because there's 28 countries in the EU, including the UK. Much more difficult to say that 50% of your value of your product was added in the UK. So what the UK would try and do is something called diagonal accumulation of origin. They'd probably try and say, look, can we say that 50% of the value of our product was added in the UK or the EU? That's much easier for you to prove, and it's much easier for you to make use of in the event of getting a free trade agreement. What the competitor country will say is, well, that's absolutely fine, as long as we can say that 50% of our product was made in Japan or China, and that therefore they'll get themselves a competitive advantage, it will reduce costs on their products, and so a lot of businesses might miss out on the value of a free trade agreement. The problem with all this lies not really with big businesses. It lies with SMEs who might look at this process of trying to prove where your products come from and say, it's just too difficult, we can't do it, we'll just pay the common external tariff. So that's one way in which a lot of businesses might not get the advantage of a free trade agreement, and why a free trade agreement might not be as useful as just a simple customs union. Okay, so they're the building blocks of Brexit. If you understand those things, you will understand much better some of the issues your business may face in the event of a no deal. But we're not necessarily going to get a no deal. So why are we saying people should prepare for no deal? Well, first and foremost is because it is just not a waste of time. If you think about what a no deal is, at its heart, it is crashing out of the single market and the customs union in an admittedly quite a dramatic short-term fashion. Think about what the future relationship of this country will be with the EU if all goes according to plan. It will be a free trade agreement. And in a free trade agreement, you will be outside the customs union and you will be outside the single market. So by preparing for a no-deal Brexit, you're actually preparing for life as it will look under a free trade agreement, albeit a pretty extreme version. But essentially what you're doing is you're setting your organisation off down a path that it may well have to go down anyway. So I don't think it's a waste of time. Secondly, you've got to think about your customers' expectations. No deal is perfectly possible. It's not probable, it's not impossible, it's just a possibility. The Ben Act, which forces the government to apply for an extension, some people say, well, that shows that Parliament will always act to stop a no deal, but Parliament will not always necessarily get the opportunity to act. For example, if there was a general election and the Prime Minister stood on a manifesto saying he wanted no deal, he'd probably have the moral force to force one through. If it happens, your customers are going to ask you, what have you done to prepare for this? And if you've done nothing, think about this pretty severe reputational harm to your business. And if neither of those things convince you, then think about Brexit as an opportunity. In a perverse sort of way, it may well be. Because there's a lot of statistics out there that show that people are just not preparing for Brexit. The CBI said recently that 4 in 10 businesses that trade internationally have a plan for Brexit, which means that 6 in 10 don't. So an awful lot of your competitors will not be preparing properly for this. Now, if they don't prepare properly for this, one of two things will happen. They will either suffer massive, possibly irreparable financial harm to their businesses, or they'll suffer huge reputational damage. If your business is in a position to continue to supply the goods and services that it supplies right now, in the event of a no deal, you will hoover up market share, you may be able to overtake other businesses, but you will be able to say, actually, we did our jobs properly, and that will be a big boom for your businesses. So, what we've done is we've thought about 7 steps for preparing for Brexit. This is going to look different for every business that takes these steps, essentially. Some businesses might think there are more steps to take, some could probably do it in fewer. The problem with Brexit, of course, is that it looks different for every business. It depends on your sector, it depends on your size of your business, it depends on your experience, and so on and so forth. But what we've tried to do is give a framework, a set of guidelines, really, that you can think about as you try to prepare for this. So, the 7 steps are: you should set up a steering group, you should conduct a business audit, you should complete a legal risk analysis, you should use the results of those things to try and work out what steps it is you ought to be taking. You would do a due diligence exercise, you'd identify some external help, because it might well be that you do need some help from outside parties in order to help you deal with possibly with a particular aspect of Brexit. And then possibly most importantly, you should open up discussions, and that's discussions with customers and suppliers and your own workforce by way of example. And we'll look at those steps in turn. So the first one is setting up a steering group. Many businesses will have done this. Really, we would suggest it's a group that should be drawn as widely as possible from across your business. There's some really obvious people to have on that group. So the first is, if you're lucky enough to have one, an in-house lawyer. Many businesses won't have that. Many businesses won't have the size or capacity to have in-house legal counsel. But most businesses will have someone who is used to dealing with the law of contract, signing contracts, negotiating contracts, and that's a great place to start. You might have someone from HR, someone from IT to deal with issues of data flow and the GDPR. It could be someone who's used to logistics or possibly has previous experience in import-export. It's really up to you who's on there, but one person who definitely should be on there is someone at board level, because really this can't be a box-ticking exercise. It has to be a group that has some teeth, ideally a budget, and if possible, someone who can implement implement a plan. And it's got a series of tasks to conduct. The first is really it's got to create a strategy and get some guiding principles together, and the guiding principles will be what's important to your business. So, for example, if you rely really heavily on EU labour, you might think, well, actually, the guiding principle of the steering group will be how do we secure EU migrants in the event of a no-deal Brexit. It might be you've got lots of intellectual property based in the EU, and you might think, well, actually, I don't quite know what's going to happen to that. Do I need to take actions to look after it, to keep it enforced, to protect it? The guiding principle will be, well, how do we go about doing that? You commission a business audit, which we'll look at in more detail in a minute. You turn your assessment into an action plan, report to the board on implementation and monitor effectiveness. So really we're saying, set the group up, let the group do its job and follow its recommendations. Okay, so let's have a think about a business audit then. What is a business audit? Well, it's really a review of your business to see where it's exposed to no deal risk. And you can't just look at your own business. It's obviously going to be important to understand how your business functions, where it interfaces with the EU, where it possibly has to comply with an EU law or relies on some sort of EU regulation or has an EU customer or supplier. But actually, you have to look upstream and downstream as well. You really have to think about your suppliers and your customers and how they might be affected, because obviously in the event of a no deal, their problems might become your problems. And a great example of that is cash flow. If your customers start having cash flow problems because of something Brexit-related, that cash flow problem could easily become your cash flow problem. It's going to be different for every business, but until you do that audit, you won't know what it looks like. And don't forget to take a really broad view of this, okay? It's not just, do I have customers in the EU, or am I exposed to an EU regulation? It might be, what might happen with the economy? What would happen if interest rates go up or if inflation rises? It might be political factors you can think of as well. Your industry might have some sort of particular political sensitivity. So think big. So in terms of that business audit then, every business is different and every business will have different priorities. But what we're trying to do is pick out some things today that we think will have fairly universal application. We're going to have a little look at some of those now. They may not affect you, but it might well be that they do affect your customers and suppliers, and you really have to bear that in mind when you go through this process. It's not just about, am I exposed directly, it's am I exposed indirectly to the effect of Brexit. So the first thing is tariffs. Tariffs will have a big effect on people, and we know there's going to be a new tariff regime. How do we know? Well, we know that we're going to be, in the event of a no deal, outside the single market and outside of the customs union. And we've talked about the common external tariff. So the common external tariff will be applied to your products if they are imported into the EU. So immediately your products become more expensive for EU consumers. Now, lots of people have said, well, why actually would the EU impose a tariff? That's going to be counterproductive. It's just going to increase costs, and they've got supply chains that come in and out of the UK, and it's going to make life difficult for their businesses. The EU have been quite clear from day one that they see it as in their words and not mine, a dereliction of duty not to impose the common external tariff and the various rules of the single market. So we're pretty certain that your products are going to get more expensive as exported to the EU. What will the UK do? Well, the UK have taken quite a different attitude to this, because the government's priority, which is quite short-term thinking, but possibly necessarily so, is that they will reduce many tariffs to zero. Now, each tariff is different. The government publishes what they call schedules of tariffs, and you can go and look at those now. They've been updated recently, and you can work out what tariff will be applied and whether or not it's been reduced to zero. Now you might think, well, reducing tariffs to zero, that's got to be a good thing for consumers, and in some cases it might be. The clothing chain Next a couple of weeks ago said that reducing tariffs to zero on imports for them would reduce their costs by about £25 million a year, and that they pass that on to UK consumers, which is great. But as we saw earlier, when you think about the most favoured nation principle, if you're reducing tariffs to zero for goods coming in from the EU, you reduce tariffs to zero from goods coming in from everywhere. And that might put an awful lot of pressure on UK businesses that produce things. And what you get essentially is what we call trade asymmetry between the UK and the EU, because You've got EU businesses that are protected by the common external tariff. They don't have to pay a tariff to get their goods into the UK, so they've an advantage twice over. And so you're getting pulled in one direction by EU businesses, and then one direction by businesses from wherever else in the world that might be able to supply things more cheaply than you under the most favoured nation principle. So you need to look at your contracts, you need to think about tariffs, and you need to think about how that tariff regime might affect you, and what is it you can do about that. Do you have to absorb the tariff costs? Can you change the terms of your contract to pass them on to someone else? Another area is customs. Customs procedures will be new for many businesses. For businesses that have never exported outside the EU, you'll never have had to fill out customs paperwork. There's some really simple things that you can do here. You need to make sure you've got an EORI number, so that's an Economic Operator Registration Identification number, which should have been issued automatically now, but you need to know what it is if you're going to import and export. You will also need to know the EORI number of other people in your supply chain, particularly in Europe if you're exporting to them. And there's all sorts of schemes that the government have come up with to help you in the event of a no-deal Brexit. We won't go into them too deeply now, but you can think about things like transitional simplified procedures, which are essentially procedures that allow you to delay paying certain taxes and import duties and filling out certain paperwork at the border. The idea of that being that it helps trade to flow, and you can fill things out at a later date. But you have to apply for it, and only 10% of businesses have. So that's something for you to think about. Can you make use of it? Do you know what it is? And do you need to apply for it? There's also things like inward processing relief, outward processing relief, and temporary admission. You need to go away and look those up, because if you are importing, there may be ways of deferring tax or claiming rebates. Think also about tariff accumulation. If goods are moving in and out of the EU as part of a supply chain, it might be that they accumulate tariffs each time they move over a border. There might be something you can do in terms of getting certain reliefs back for those things. But you may need to ask, who bears the costs of this if that happens? Logistics is another big thing. There's all sorts of ways that the logistics industry is affected. We've concentrated on hauliers here just to give you an idea of the sort of complexity. It may well be that you don't use hauliers, but just looking at the sort of things that they have to comply with will make you realise some of the problems you might face indirectly in the event of a no deal. So hauliers will need to ensure that the drivers have the correct international driving permits. There are 3, depending on whereabouts you want to drive in Europe. They'll need at least 6 months left on the drivers' passports. The drivers will need a certificate of professional competence. The hauliers themselves might need a European Conference of Ministers of Transport permit. They might need a bilateral road haulage permit. They might need a trailer registration. It's complex. And we're going to talk a little bit later on about doing due diligence, making sure that your customers and suppliers have got in place the things they need to deal with Brexit. Remember that statistic that we quoted earlier about the number of businesses that aren't ready to deal with the EU, something like 6 in 10 in the event of a no deal. You need to make sure that, for example, your hauliers, the people providing your logistics, have these things in place, because they may not have. Think also about costs as well. Most hauliers operate on a something like 2% profit margin. They are not going to absorb the costs of leaving the EU. It will be passed down to the supply chain. Can you absorb that cost? Do you need to? That's something you need to think about. For a lot of businesses, regulated goods is a big issue. Lots of goods are regulated by the EU for sale in the single market. So there's a series of rules that have to be complied with for you to be able to sell into the EU. Now, at the moment, inside the single market, you manufacture your products, you manufacture them already to EU standards, so you can export them under the terms of the single market. That's not a problem. However, that's going to change in the event of a no-deal Brexit. Because what will happen is the EU have said they will not recognise our notified bodies anymore. Now, our notified bodies are bodies that can basically come into your business and say, yes, your product complies, here's a certification, you can sell it in the EU. So that means that first and foremost, if you want to get your products certified for sale in the EU, you're going to have to go to an EU country. And there's a cost to that. You might have to go to Ireland or the Netherlands or somewhere like that to get it done. Secondly, the UK has decided it's going to set up its own notification bodies and its own notification process, and that's called the UKCA. And what that means is, when that's introduced, and it probably won't be immediately, you'll have two different compliance regimes to cope with. You'll have one for products you sell into the EU, and you'll have one for products that you sell in the UK. Now initially that probably won't be a big issue, because the day we leave we'll obviously have exactly the same laws as the EU and our products will automatically comply. But over years, possibly even months, as regulations start to move apart and you get divergence, which is one of the aims of the government to move away from EU rules, then you might find you're going to have products that have to comply with two very different schemes. And there might be a cost implication for that for you. In the event of a no deal, the EU have said that they will probably continue to recognise UK products that have a current CE mark. So that's a current mark that allows them to be sold in the EU. But they won't recognise new ones unless they are provided by notified bodies in the EU. Different for the UK, they'll take a more relaxed attitude, I think, and they'll continue to recognise the CE mark until the UK CA process is underway. Again, that's really to allow trade to continue uninterrupted as it comes into the UK. But you need to think about moving product registrations to the EU or even duplicating them. One big area that you're going to have to look at in your business audit is people. There is an EU settlement scheme in place which is thankfully relatively generous. It essentially allows people to settle in the UK who are here before Brexit on the same terms as they're here as EU citizens. The fee the government originally charged for this has been waived, and it will provide people in the UK with the right to use the NHS, to have a state pension and to be here on a permanent basis, which is excellent news. The issue is not really one of the law, it's probably one of culture. In the event of a no deal, it's quite likely that that no deal might become quite acrimonious. Politicians in particular using language that they maybe shouldn't, and we've all heard probably of a blame game between the EU and the UK as to whose fault a no deal is. You have to consider whether or not that is going to have some sort of impact on perhaps people from EU countries who are working in your businesses, and monitor that very carefully. And a really important thing you can do to help out with that situation is to have a communication plan. So in the event that there is a no deal, or even if a deal is signed, have a plan ready to go that tells people in your business, whether they're from the EU or the UK, what it is you're doing to prepare for Brexit, what it means, how much you value the people who work in your business, generally setting some guidelines and giving people some confidence in your business about what's going on in the event of a no deal. We've seen a few businesses setting up buddy schemes, which are just schemes that essentially you buddy up someone who perhaps is a migrant and maybe doesn't have the same English language skills or the same confidence with someone from the UK to help them through the process. So migrants are one thing you want to have a think about, and people in your business in general. Data is another big issue, and currently we can essentially import people's personal data from the EU, and there's no issue with that provided we comply with the GDPR. In the event of a no deal, we won't have an adequacy decision from the EU to safeguard the free flow of data. So what that means is the EU will look at our country and essentially say, well, is that really a safe place to send personal data? And their immediate answer to that will be no, not until we have checked out whether or not it is safe and given an adequacy decision. And that can take up to 18 months. 18 months is the quickest indeed that an adequacy decision has been reached. Now there are ways around that. So you could, for example, have standard contractual clauses in your contract that set out certain rules and regulations as to how you will treat personal data, and that will be seen as a safe way to send data to you. The issue you may have in a no deal, obviously, is that you don't want your, for example, Italian customers to not be able to send their personal data to you because it's illegal, because the UK is not a safe place. So look at your contracts, look at your business, have a think about where personal data comes in and what you need to do to protect it. Okay, so step 3, once you've done your business audit, and we've just gone over some headline points there, is to do a legal risk analysis. And that's really just looking at the legal impacts of Brexit and how they might affect your business. And it could be a number of ways. It could be new legislation, it could be an issue in your contract, it could be something industry specific that you need to think about. And you'll need to review your contracts to see where you're exposed to risk. We're going to have a little bit of a more detailed look at that later on, so we'll skip over that for now. But just a signpost at this point, One of the things you could do is look at what the government call the technical notices. So these are a series of notices that have been posted on the gov.uk website that tell businesses in different industries what they need to know about Brexit. One particular area of concern for a lot of businesses is intellectual property rights. There's a great notice on IPR on the government website which gives you a flavour of what will happen and what you need to do. So go and look at the technical notices. So the fourth step really is just to use the results. Use the results of your business audit and have a think about what you need to do to make some changes to your business to get it ready for Brexit. So for example, it might well be that you need to identify some alternative suppliers or supply routes. You might need to think about stockpiling. Can you do it? If you can do it, if you need to do it, is cash flow going to be an issue for you? Or warehousing? Do you have capacity to store anything you might want to stockpile? Think about delays to supply and contractual issues. Are there penalties in your contracts that say what will happen in the event that you are likely to make late delivery, and having done your business audit and realised that actually your suppliers might not be able to supply you on time, is that a risk for your business? Are you at risk of breaching contract? Is there something you can do about that? Can you shorten your supply chains? Can you apply for certain procedures like the transitional simplified procedures that we spoke about a little earlier? Can you address IP and data issues? You really just need to apply what you found and try and work out some ways of how you might mitigate the risks. Step 5 is to do due diligence. This is the simplest and most effective step really. You need to go away and ask the businesses you deal with, customers or suppliers, what they have done to get ready for Brexit. You need to be really hard-nosed about this. Prepare a questionnaire and ask difficult questions. And you go back and think about the logistics providers we talked about before. You should be sending a questionnaire to your hauliers saying, do you comply with the relative EU regulations you need in terms of paperwork to get over the borders? Do your drivers have 6 months left on their passports? Do they have the right paperwork, and so on? If they can't answer your questions or they refuse to, then you've got a problem and you might well be finding a different logistics provider. But also be prepared to be asked those questions and don't be frightened to answer them, because if you can answer them, if you have been through this process, you're going to be in a far stronger position than an awful lot of businesses. Step 6 is to identify some external help. There's lots of people who can help you out there. There are lawyers, there are accountants, freight forwarders, customs brokers. There's obviously the Chamber of Commerce, which has some great resources to help with things like import and export. There's the CBI, who have helplines for helping businesses in the event of no deal. There's all sorts of trade bodies. And don't forget as well your business networks. Cumbria is a really well networked place, and it might well be that you've got people in your business networks who can give you really good, really practical, really commercial advice and guidance. Don't be afraid to lean on these people. And step 7, the final step, is just to open up discussions. So it might well be you want to open up discussions with your suppliers, and we'll have a little look at that in a minute when we think about contracts. It might well be you want to open up discussions with your customers and talk to them about the problems you're having and ways that you might be able to resolve those things. Or it might well be that you're telling them, look guys, we've actually prepared for Brexit really well, you can rely on us. We've talked about your employees, we've talked about networks. A really great way to reach people is to put a Brexit statement on the front page of your website. And that statement should say, these are the steps we've taken, this is what we've found, this is how we're mitigating risk, this is how we're going to continue to supply goods and services in the event of a no deal, these are the reasons you can rely on us. Lots of businesses are doing that now, lots of businesses of all different sizes, and you might find you're left behind if you don't do that, and it might be a really quick way of reassuring your customers that you can continue to supply them in the event of a no deal. So, they're the 7 steps to preparing for Brexit. We looked briefly at one of those steps, which was doing a legal risk analysis, and we're going to have a little bit of a look at that a little bit more closely now. Now, really for a lot of businesses, this is going to come down to looking at your contracts, having a review of your contracts to see what they say. Why your contracts? Why should you review your contracts? Well, your contracts will tell you what you can and what you can't do in the event of something happening that's no deal related, so a change in price or a delay in delivery, something like that. So that's going to help you with your planning, because if you know what you can and can't do, you're going to be in a much better position to work out what it is you need to do in the event of a no deal. It's going to show you where your risk lies, and some really obvious examples of that. So think about an increase in exchange rates, or a change in exchange rates, or the imposition of an import tariff or an export tariff. How will that affect the price of your contract? It probably will affect the price. Can you pass that price change on? Can you still afford to perform that contract? Those answers are only going to lie in your contract. Think about things like border delays. Will that affect your delivery times? Is there a penalty in your contract for late delivery? You need to think about these things, and the answers to that will be in your contract. Similarly with parallel regulations, we've talked about 2 different regulatory regimes. What about the ending of free movement? Do you rely on migrant workers from Eastern Europe to produce your product at a particular price? Will that change the price of your contract? Do you have freedom to provide services? All of these things you can think about in terms of your contracts, and see what your contracts say about them. And a really great place to start with this really is to think about changes in the laws. So before we get into looking at your contract, let's think about the fact that we're leaving the EU. A lot of businesses say to us, well look, we're leaving the EU, can we basically have a bonfire of EU legislation? Can we throw all our books on the GDPR onto the bonfire and not worry about it any longer? And the sad answer, possibly for a lot of people, is well, no you can't. The reason for that is that the UK passed the EU Withdrawal Act 2018 last year, and it basically, the effect of it is that when we leave, our laws won't change. They've done that for some very good reasons. One is that they just didn't have time to change a lot of the laws that they might like to have changed. One is that they probably haven't thought about what it is they actually want to change. But one is that for the sake of your businesses, you probably want to know there's not going to be a big change in the law. So they're going to keep things the same, at least for now. So anything that's come down from the EU, or indeed any Act of Parliament that is a UK initiative, won't change immediately. And that means that you're going to be stuck with the GDPR, with the Unfair Contract Terms Act, with the Sales of Goods Act, the Supply of Goods and Services Act, the Consumer Rights Act, and so on and so forth. But of course, not all of our laws are made in Parliament or the EU. We also have something called the common law, and briefly that's law that's made in court. So what will happen is judges will look at court cases, make a particular judgment, and other lower courts will work out the method of thought and follow it until you get rules of behaviour and patterns of behaviour that get passed down over the years, and they become rules that basically inform the way contracts work. So a great example of that is rules on offer and acceptance. It doesn't come from Parliament or the EU, it comes from the way courts interpret contracts. Consideration, this idea that you have to have an exchange of one thing for another for a contract to be enforceable. That comes from the courts. So that isn't, again, going to change. Leaving the EU won't change the way that courts interpret the law. It's certainly not to begin with. So if the EU law and the UK law as it applies isn't going to change and isn't going to affect your contracts, and if the common law isn't really going to change, then what you have to do is think, I must look at the actual terms of my contract. What has been agreed between me and the other party to see how Brexit might affect things. So that will be looking at your current contracts, the ones that you already have signed, and your future contracts, the ones you'll sign eventually. And I guess the first question to ask yourself is, can you just do nothing? And it's quite possible you could. You could look at your contracts and think, actually, I don't need to make any changes whatsoever. It might be you've got a short termination right that says something like either party can terminate the contract by giving 3 months notice with no further liability. So you could just say, well, we'll sit it out, we'll see what happens with Brexit. If there's a no deal and it causes me problems, I'll just terminate the contract, and you don't have to do anything. It might be that your contract has run its course. Perhaps it was for an initial term of a few years and it's rolling on a month-to-month basis. Again, if you can get out of it or it's coming up for renewal, you maybe don't need to do anything with it. Perhaps you look at your contract and you think, well, Brexit might happen and a no-deal Brexit might happen, but actually it doesn't really affect my contract. I'm quite happy with it. Well, again, you're in a lucky position and you don't have to do anything about it. But if it imposes an additional cost or a burden, you're probably going to want to make some changes to your contract. We talked briefly about the common law. the way essentially judges interpret cases and the rules that courts apply. Can that help you in the event of Brexit? If you get to court in some sort of dispute caused by Brexit, will the way the courts traditionally interpret contracts help you out? And the answer to that is probably no. There's some examples on screen at the minute of some of the sort of rules that have been laid down by the courts. So one is that judges will always give words their natural meaning. What that means is that they'll look at the contract, they'll read it as naturally as possible, and they won't try and skew the wording to help a party out. So if you've made a bad deal, or even a good deal that's become a bad deal because of Brexit, they're not going to help you out by interpreting the words in your contract in a particular way. One of the things they've said is that they won't imply terms into contracts. So you might have signed a contract with someone and you might have thought this was what the contract was about, but if the contract doesn't say it, the court won't imply a term in to help you. They would only do that if it's so obvious it goes without saying, or it's just necessary for business efficacy. They've also said they won't rescue parties from a bad deal. So if you're suffering economic hardship as a result of Brexit and you want the court to help you out with the contract, they are not going to. One thing that might help is something called the doctrine of frustration, which we'll look at very quickly. Frustration is essentially an event that occurs that allows you to treat the contract as discharged. So you can walk away from the contract. And a frustrating event is one that makes the contract impossible, illegal, or radically different. It's a really high bar. And it's really high because the courts don't want people to break contract just because of something happens that makes the contract more difficult to perform. To underline, this is not about the contract becoming more difficult, it's about the contract becoming impossible, illegal, or radically different. Now, the one question that's been raised is Brexit a frustrating event? Could we use Brexit and say, actually, this frustrates the purpose of this contract, we no longer want to perform the contract? That's probably very unlikely. Brexit probably won't be a frustrating event because it has to make performing the contract impossible, illegal, or radically different, whereas in a lot of cases all that will happen is it'll make the contract more difficult to perform, not impossible to perform. There's an issue of foreseeability here as well. The frustrating event has to happen after the contract is signed, and in a lot of cases Brexit will have happened first and the contracts will have been signed since, so the parties will have known about it, and for that reason it can't be a frustrating event. So Brexit probably won't meet the test, and the common law is probably not likely to help you. So we look at your contract then. On the screen now are some of the clauses that might help you with your contracts in the event of a no deal. So you could have a force majeure clause in your contract, a compliance with the laws clause, a change control clause, a hardship clause, they're sometimes referred to as material adverse change clauses, or you could have termination rights in your contract. And we'll go through each of those in brief. So a force majeure clause then is a clause that allows a party to suspend its obligations under the contract where an event occurs that's outside that party's reasonable control. So a great example of this is an act of God, and they're often called act of God clauses. Essentially it's where you get a clause that says in the event that there is a hurricane or a fire or an earthquake or a nuclear accident or a strike or a civil war, if that causes a party to be unable to perform its contract, that party can suspend its obligations under that contract for a period. And 3 or 6 months is often a period that's used. Again, the question is, could you say, in the event that your contract becomes more difficult to perform, that Brexit is a force majeure event? I mean, it's certainly an event outside of your control. And that is an argument that some lawyers have sought to make. It's unlikely, but it's not impossible. Brexit itself is unlikely to be a force majeure event because foreseeability is an issue. If the parties could foresee that it might happen, it's probably not a force majeure event, and most people have known for quite some time that Brexit will happen. The other issue with force majeure is that often it will allow a party to suspend its obligations for a period. But Brexit's going to apply for decades, so how long would the temporary application actually apply? How helpful would it be to you? Would suspending your obligations for 3 months be useful when Brexit goes on for a generation? It probably wouldn't be. Brexit might cause an event which could be a force majeure event though. So often in a in a force majeure clause you'll see it says something like in the event of a force majeure event the parties can suspend their obligations, and a force majeure event will include one of the following: earthquake, fire, so on and so on. One of the things might be, for example, strike action. And so if there's strike action in your company, possibly caused by no deal Brexit, some sort of issue over wages, something like that, it could well be that you could rely on a force majeure event to help you out in limited circumstances. But it might not be the answer to all your problems. One interesting clause which exists in a lot of contracts is the compliance with the law clause. And simply it says that the parties will comply with the law. But it will often say either the parties will comply with the law at the time that was in force at the time the contract was made, or it will say the parties will comply with the law as it's changed from time to time. If your contract says we will comply with the law as at the point the contract was made, that may help you if there is regulatory divergence and EU laws change and you're contracting with a party in the EU. You may be able to point to that contract and say, well, actually, we don't need to change what we're doing, we don't need to change the specification because we only have to comply with the law as it was when the contract was signed. It may not be much help to you if the EU business says, well, we need to comply with the law, we need products that will comply with the law, but it may at least give you some flexibility. If your contract doesn't say when the laws were drafted that must apply, so if your contract doesn't say the laws that applied at the time the contract was drafted or the laws that are reenacted or modified, then there is a presumption that it's probably the laws as they are modified from time to time. But there may be narrow exemptions to that. So change control, this is another sort of clause that may help you out. Essentially a change control clause sets out a process where the parties can get together and there's a specified way of making changes to the contract. You can't often force those changes on the other party, but it is often a gateway to going to your colleagues in different businesses and saying, look, we've got a contract with you, we'd like to make some changes to it because of Brexit, can we use the change control clause? And it'll set out a way of making changes. So it'll say a certain person in your business has to talk to a certain person in their business, a certain notice has to be given in a particular form, and these are the set list of things that can be put in place if a change is to be agreed. One of the things you have to think about here is, what is the consequence of using that change control clause? Because often what will happen is you'll have a change control clause that says either party can make a change to the contract, but if the contract, or the parties can't agree that the contract ought to be changed, then the contract might be terminated. If you want to go through the change control procedure and you go through it and you don't manage to agree a change, ask yourself, do I want this contract to be terminated? You might be reliant on that contract, you might be trying to change it to make it better, but you'd be willing to put up with it if you couldn't change it. What you obviously don't want to do is give the other party an opportunity to say, well, we haven't managed to agree this change, we want to be able to terminate. But it will be potentially a means of opening discussions. Okay, the next clause is a hardship clause. So this will help a company, if it is in your contract, deal with a particular issue that arises with that contract. So it's generally something that's been agreed between the parties at the time the contract was made. So the parties might say, well, look, if there's an increase in the cost of raw materials, this is the result. We'll be able to say increase prices. Or if there's a change in the interest rate or the exchange rate, will there be a fluctuation in prices? You might be able to look at your contracts and find a hardship clause and rely on that in the event of a no-deal Brexit, because a particular trigger occurs, like a rise in interest rates, which cause the cost of your products to rise, and you may be able to pass that on. Having a look at your contracts, having a look to see whether they contain those hardship clauses will be helpful. And think about what the hardship clause actually says. Is there a prescribed change, i.e. is there a change that the parties have to take if one of the triggering events occurs? Or is it just an obligation to negotiate? And think again, what happens if we can't agree? Does your contract state what will happen, or do you need to agree that with the other party? Termination is going to be pretty much in most contracts. Most contracts will have a termination clause. Some contracts are negotiated so that a party can essentially walk away without any liability or any wishes. We call that termination without cause or termination for convenience. And essentially, contracts that contain this will allow a party to generally to give a period of notice and say, actually, we just want to release this contract. You need to look at that, and that's obviously a double-edged sword, because that might help you in the event that your contract becomes more difficult to perform, but also a customer or supplier might rely on that as against your business. And unless you know where you have those clauses, you're not going to know where you might get a sudden termination of a contract from, say, a supplier. Often termination will just be allowed where there's a material breach, so in layman's term, a particularly serious breach of the contract, and often the contracts will set out what a material breach is. You might have to have a look at that. Does that put you at risk? For example, if your contract contains a clause that says, in the event that payment is delayed by more than 5 working days, that is a material breach, you might have to consider, is it likely that we may make late payment? If we do make late payment, does that mean that the other party is going to have an easy route out of this contract? It could also be a negotiating tool for you. You could go to your suppliers and say, look, we've got a contract, we could get out of it quite easily, we'd like to renegotiate it, because we're a bit worried about no deal Brexit, can we put the following clauses in? And if your contract is strongly enough in your favour, that might not fall on deaf ears. And think about your contracts. Do you want to terminate them? You may want to, in some cases, get out of a contract that's become onerous, but think commercially. It may well be you don't want to terminate a contract with a supplier who is going to supply you late or pay you late, because actually it'd be really difficult to find another supplier. So it might well be easiest to keep a difficult supplier in check rather than get rid of them using a termination clause. So they're clauses that may or may not be helpful in particular circumstances for you. What about problem clauses? Well, one really obvious example is any clause in your contract that refers to the EU. And what you particularly need to look out for here are things like changes to trademarks or sales territories. So to give you an example, you might have a sales territory in your contract that allows you the sales territory of the European Union. Well, that might cause you a real problem if we exit, because all of a sudden your sales territory may not include the United Kingdom, as will be outside the EU. Have a think about that. Do you need to go back to the other party and say, actually, we need to renegotiate this contract? Does it say, instead, your sales territory will be the member states of the European Union from time to time? Will it actually mention the UK specifically and say, including the UK, if we leave the European Union? Is it still appropriate? These are things that you need to have a think about. And another issue is, where will judgments be enforceable? If you get a judgment against, say, a European business in the UK courts, in the event of a no-deal Brexit, will that judgment be enforceable in the EU in, say, 6 months or a year's time? There is no really easy legal answer to that. It probably will depend on what is agreed between the government and the UK post a no-deal Brexit. And that might be something where you need particular legal help. Okay, so you've looked at your contracts, you've decided that your existing terms perhaps don't help. What can you do? Well, you might be able to renegotiate on some of the reasons that I've talked about today. You need to do your homework and work out what you want to get out of that renegotiation, and also be really careful about the way you vary your contracts. Remember, you can vary contracts in some circumstances just by talking to someone and agreeing something that you maybe don't get round to setting down in writing. It could be an oral variation to your contract, and it might not be helpful to you. Can you stockpile raw materials or inventory? Would that be helpful? Can you identify a different delivery route? Can you bring supply in-house? These are all things you need to think about. And something else you need to look at is, if none of those things help, if I can't do anything to mitigate the risk in the contract, what is the risk that I breach my contract? What you have to look at there are limitations on your liability. What lawyers will always try and do in a contract is limit their client's liability. So they'll say, in the event of a breach, the maximum liability that can be imposed by the parties is, for example, £100,000 or £1 million, or the value of the contract in the year in which the breach occurs, whatever it might be. You need to look at your limitations on liability. If your limitations on liability are really high, then you might end up paying an awful lot of money in the event of a breach of contract, in which case it might be better for your business to keep supplying under that contract rather than breaching the contract. If they're really low, you might look at it and think, oh, actually, if we did breach our contract, the maximum we'll be exposed to is a low amount of money. That's much better than continuing to perform the contract for the next few years. So have a look at that. So they're your current contracts. What about your future contracts? What about inserting some sort of Brexit-related clause to help deal with what might happen in the event of a no deal? And we do see this from time to time. It essentially would be a clause which triggers a change in the rights or the obligations as a result of a specified event. So it would say something like, if X happens, then Y will be the result. What would the main triggers be? Well, we talked about some of these things on an earlier slide, but the things that might cause financial hardship. So in the event that Brexit causes a rise in interest rates, can we change the price of the contract? In the event that Brexit causes an import delay, can we change delivery dates? That might be how a Brexit clause works. So you'd have an adverse effect, and the trigger must result in an adverse effect. You'd want to make sure that you put some metrics in your contract so the parties can look at it and say, we can definitely judge that this has happened, and that'll help you avoid a dispute. So for example, you might want to say, if prices rise by more than 5%, we can increase the value of our product. And think also about the duration of the trigger event. How long do you want it to last? Because obviously Brexit is something that might last for, as we say, generations rather than a short period. One problem when drafting these is the word Brexit. You're going to have to ask yourself, was Brexit the cause of the issue? So if you're drafting a clause that you think is going to be helpful that says, in the event that Brexit causes a fall in the value of sterling, we can change the price of our contract, what you will no doubt find is that the person on the other side of the contract says, can you prove that Brexit caused the fall in the value of the sterling? How do you prove that Brexit caused it? Could it have been other factors? What you might instead want to do then is leave any reference to Brexit out and just have a clause that says, in the event that there is a price rise, in the event there is a fall in the value of the sterling, in the event that delivery is delayed, we can do one of the following things. And that might help that Brexit clause from failing. Brexit's a real problem because Brexit might, for example, be the indirect cause. Brexit might cause some sort of industrial dispute in your company because of problems over, say, the wage you're willing to pay workers. That might cause you to not be able to supply under your contract. The actual cause of failing to supply is not necessarily Brexit, it's the industrial dispute. Brexit's a bit further up the chain, so Brexit might be an indirect cause or might not be the sole cause. You might have to think, well, what happens if the result occurs pre-Brexit? I mean, lots of businesses are suffering Brexit-related things now, but Brexit hasn't actually happened, so be very careful about how you use the word Brexit and how these changes pan out across your contracts. Think about possible outcomes. So you've got a Brexit clause in your contract. It allows you to do something in the event that your contract somehow becomes more difficult to perform. What is the result you want from that? It's probably going to be one of three things. You're either going to want the ability to renegotiate the contract, you're going to want a particular prescribed outcome, like a price rise, the ability to pass a cost on, or you're going to want to be able to terminate the contract. So very briefly, we'll look at those. Think about renegotiating your contracts. What you don't want in your contract is a clause that says, we will, in the event of a particular issue that causes prices to rise for our products, we will negotiate a new price for the products. That's an agreement to agree, and the courts won't enforce them because they lack clarity. You can't force someone to agree to something. So what you want really is a binding process, something that says, if Brexit occurs or if there's a rise in prices, for example, the result will be this, we will do this, and you'll want an intended outcome from that. Be careful on this because what you'll always be asked to do is provide evidence that you're not just pulling a fast one and trying to make a bit of money out of this. So what will often happen is lawyers on the other side of any contract negotiation will say, well, that's fine, we can do that, but you're going to have to provide us evidence that your cost has risen, so we want to be able to audit your business. And that might be something you have to put up with if you want a clause like this. And think about failure. What happens if you fail to renegotiate the contract? Do you just keep performing the contract, or is there a termination right? You might want a prescribed outcome, so you might want to revise a lead-in time or a delivery route. You might want to vary a specification, but you're going to have to think who picks up the costs of these things. And that should be drafted and included in your contract, so it's clear from the start, because you don't want to get into a situation where you have a clause that allows a prescribed outcome, like increasing a cost of supply, but then have an argument about who picks up a particular cost, even if that's something like who pays the legal fees for redrafting that part of the contract. And think about metrics. How do we prove that something's happened? How do we measure it? Finally then, termination. You might well think, well, I've got a Brexit clause, it'll allow me to terminate rather than renegotiate, or it'll allow me to terminate rather than have a prescribed outcome. Which party gets to make use of the termination clause? Is it for both parties? Is there a time limit? So for example, if there's an effect caused by Brexit, do you have to terminate within 6 months of that effect, or a year of that effect, or can it be done at any time? What's the process of termination? Do you have to go through a particular process of providing notice, for example? And what would the notice period be? And think about the consequences of termination. If you're going to terminate a contract midway through because of something Brexit-related, what happens to existing orders that have been placed with you? Will they be honoured? Should be included in the contract. Will you have to return documents or intellectual property or IT equipment? Again, should be covered in the contract. And how are final payments worked out? Will you get paid if you only supply part of a production run? Will you get paid pro rata? Again, something that needs to be considered. So some final thoughts on this then. Think about assignment of contracts. Lots of contracts will have a clause in the back that says either party can assign this, or only one party can assign their rights under the contract. That might be really important. You might essentially want to give the contract up to another company because you can't perform it anymore. You might want to assign your rights under it. Does the contract allow you to do it? Similarly, your contract or your company might be bought or might buy another company. Will the contracts come with the company? Will they need to be assigned? Is it just an asset purchase? If it's just an asset purchase, then there'll need to be an assignment of contracts. Do the contracts allow you to do that? Look in the small print of your contracts and have a think about these issues. Often contracts specify certain staff that have to provide a service. Will those staff still be with you in the event of a no-deal Brexit? Do you rely on particular named experts from the EU who are providing products or services? Will you still be able to supply those services using those people? And think about no waiver clauses as well. We talk about being commercial and we talk about thinking, do I really want to hold my supplier's feet to the fire in the event of a no deal, or is it actually going to be better for me to slacken off my terms, to give them a bit of breathing space so it allows them to continue in business, which is going to be potentially a big advantage for you? If you waive your rights under a contract and in a year's time you want to reinstate those rights and say, well, come on, you've had enough time now, we want to be supplied by the date that we agreed, you've got to make sure you've got a no waiver clause in your contract, because a no waiver clause will say we can waive rights under this contract, but we can reapply them at any time. Without that contract, without that contractual right, without that clause, you may find that you waive your rights under a contract and you can't get it back. So really, looking at your contracts is all about understanding your rights and your duties, understanding your obligations, understanding what you can and can't do with your contracts, but trying to take the commercial approach to it. Not just what does my contract say I can get away with, but what is the right thing to do with a particular supplier. So that's the end of this webinar on preparing for Brexit. If you want any more help or advice on this, contact the Chambers of Commerce. You can reach them on 0845 226 0040.